As a realtor, your number one objective is to protect your client. Your number two objective should be to protect yourself and your brokerage. Today, I want to talk to you about temporary occupancy agreements, particularly early occupancy agreements, where the buyer takes possession of the property before closing. So I want to set up a scenario for you. I saw this question posed in a Facebook group that I'm a member of, and it really got me to thinking about how temporary occupancy agreements work. I'm in Georgia, so I'm going to be talking about this from the perspective of a Georgia realtor. My name is Sharon Smoot. I am a realtor in Georgia. I am also a closing attorney in Georgia. So I have a lot of interesting insights that I can offer to you on this subject matter, as well as a lot of other topics. So let's get into temporary occupancy agreements. And I want to share this scenario with you. A buyer and a seller agree that the buyer can take occupancy of the property before closing. The buyer moves in, and the very next day, the dishwasher breaks and floods the kitchen. There's damage to the flooring. Of course, the dishwasher is malfunctioning. And the question is, who is responsible for the damages and for repairing or replacing the dishwasher? Is it the buyer or is it the seller? So I saw a lot of different answers in the group, and this particular group is made up of real estate agents from all over the country. So the first thing that I want to tell you is that you've got to know how temporary occupancy agreements work in your state. Like I said, I'm in Georgia, so we're going to focus on how they work in Georgia. And I'm going to do a screen share with you. The appropriate form that should be attached to your purchase and sale agreement when you are doing a temporary occupancy agreement in Georgia is F-222 if we are dealing with the situation where the buyer is taking possession early. So let me pull up the F-222. All right, here we go. So this is the F-222 in Georgia. And like every document, you've got to fill in the offer date, the property address, and the parties to the agreement. Elizabeth Smoot is me. Elizabeth is my middle name. So this is just a test document that I created so that I could print it out or download it. All right. So the first thing that we're going to do in paragraph 1 is fill in the date that the buyer is taking occupancy, the date and the time. Paragraph 2, we're going to fill in the amount of money that the buyer is going to pay per month. And you are going to have to put in the daily amount, multiply that by 30 to arrive at the monthly amount. And then you're going to fill in who the rent is to be paid to, how much of a security deposit is going to be paid. That's paragraph 3. And paragraph 4 says the buyer will accept the property in its present condition, except as provided in the agreement as follows. So in the scenario that I gave you, where the buyer took occupancy, she had had the property inspected already. During the inspection, the dishwasher operated perfectly. The day after she takes occupancy, the dishwasher breaks. So it's very important that if you know of any issues with any of the systems in the house, if there is any damage and you are taking occupancy despite there being this particular item of damage, whether it's scratched floors, a broken window, a malfunctioning HVAC system, whatever, you need to make sure that in paragraph 4, you are making note of whatever those exceptions are. So paragraph 5 is going to give us the answer to the question, who's responsible for repairing the dishwasher, and any damage that was done in the kitchen when the dishwasher flooded. So I don't like for people to read to me. I'm just going to give you a moment to read through paragraph 5, and I will summarize it while you're reading. Essentially, what this says is that the buyer becomes responsible for the property upon taking occupancy, and that the seller is relieved of responsibility for the property once the buyer takes possession. The sentences that I will draw your attention to are the last couple. It says that the buyers had an opportunity to inspect the property. Said inspections are to be completed prior to occupancy, and buyer must object in writing at the time of occupancy to any defects in the property or waive any further claim in relation thereto. So that's where paragraph 4 comes in. That's where the buyer can object in writing to any issues with the property. And if that's not enough room, then you attach an additional page, and there is an additional page provided by GAR that you can use to fill in any other exceptions or objections to the condition of the property. So then we go on to say that commencing on the date of occupancy, buyers shall maintain said property in good working order, shall keep the roof watertight, and shall properly maintain the grounds of the property. The responsibility of seller for property shall end upon occupancy of property by buyer. That's pretty surprising, right? I know if I posed that question to you again, before you read this, you would have said that the seller is responsible. In that group, a lot of people were saying that the seller is responsible, but in Georgia, pursuant to the terms of the temporary occupancy agreement, Form F-222, the buyer is responsible for the property. It is so critical that you understand this before your buyer moves in. And it might be a situation where once you bring this to the attention of your buyer says, nah, I don't want to be responsible for the property. I'll go stay with a friend or a relative, or I will get a hotel room for a couple days, and I'll put my stuff in storage, whatever. But it's critical that your buyer understands this. So paragraph 6 says that the buyer can't make any alterations or repairs to the property or improvements to the property without obtaining the express written consent of the seller. And if the seller consents, the buyer has to pay all third parties and provide receipts to the seller showing that the work has been paid for. If the buyer makes any alterations to the property in accordance with paragraph 6, the buyer agrees to indemnify and hold harmless the seller, the seller's agents, the buyer's agents, and their affiliated licensees from any claims or loss, including reasonable attorney's fees related to personal injury or property damage caused by or arising out of the making of said alterations, repairs, or improvements. So now we're going to move on to paragraph 8. The buyer has to put all the utilities in their name. And, that's just the same as if the buyer were renting a property. And in essence, they are renting the property on a temporary basis. So the next really critical paragraph is paragraph 9, which says that the seller shall, at seller's expense, maintain fire and extended coverage insurance until the date of closing. The buyer acknowledges that this insurance will not cover the buyer's personal belongings. That means that the buyer should get renter's insurance, and whether renter's insurance would be available for a temporary occupancy situation is something that every buyer should inquire about with their preferred insurance company. So let's talk about this fire insurance and the extended coverage. The fire insurance protects the structure in the event of fire. The extended coverage protects the structure from other hazards. That could be wind, it could be rain, it could be flooding, it could be vandalism, it could be lightning. But what you need to know about that extended coverage is that it is a rider to the fire insurance policy. It doesn't automatically come with the fire insurance policy. It's not included in the fire insurance policy. So that means that your seller has to specifically request the extended coverage policy. And that's really, really important. You never know what might happen. And if it's not fire, if it's something else, you want to make sure that the structure is covered. The other thing that you want to make sure of when you are switching to this type of insurance is that you add the lender, your current mortgage holder, or that your seller adds their current mortgage holder as a mortgagee on the policy. So in the event that anything happens, then the lender's interest in the property is protected by insurance. So I'm not going to go through the rest of the document. I really wanted to focus on who's responsible if a buyer takes possession early and something breaks, there's damage to the property, something malfunctions, whatever. And like I said, a lot of people, a lot of agents would assume that because the property is still titled in the seller's name, that the seller would be responsible. But that actually is not the case. The buyer, at least in Georgia, is responsible once they take occupancy of the property. So when you have a situation where for some reason the closing is not going to be able to happen and uh, maybe the buyer needs to take possession early, uh, they've moved out of their home already, everything is on the truck, what are they going to do with all of their stuff? You know, they just need another 30 days or maybe another 15 days. And your seller is going to allow them to take possession early. You need to make sure that your seller understands the ramifications of the early occupancy agreement or the temporary occupancy agreement. Explain to them about that insurance and also explain to them that they are not responsible, because the gut reaction, I think, of many buyers, if the dishwasher breaks or if the refrigerator that's included in the sale breaks or if the HVAC stops functioning and, you know, it's 90 degrees in the middle of July, is to pick up the phone and call the seller and say, hey, this isn't working. Can you get somebody out here? Your seller needs to know that they are not responsible. Likewise, if you're representing the buyer, you need to make sure that the buyer knows that they are responsible for anything that breaks in that house. And in this age of e-signing, I think that a lot of buyers open up the e-sign request and they just sign. They don't go through the document. Like I said at the beginning of this video, your number one obligation is to protect your client. So if you're representing the buyer, explain this document to them, explain all the documents to them before they sign them. But this is such an unusual situation. I can't think, I've been a realtor since 2006. I don't think that I have ever had a situation where the buyer needed to take occupancy early. I've had a couple situations where the seller needed to stay beyond 30 days, and we did a temporary occupancy agreement. And I'll talk about the temporary occupancy agreement for sellers in another video. But it is just critical, whether you're representing the buyer or the seller, that they each understand exactly what their obligations and their rights are as it pertains to Form F-222. I don't know why I can't say 222 today. And the buyer's early occupancy of the property. So if you haven't already done so, please subscribe to this channel, like this video, share it with anyone you know who may be interested in learning more about early occupancy agreements. And check out the description below. There are some links to some handouts, some downloadables, free downloadables, some realtor merch, things you might like. So check it out, and I will be back real soon with another video.